Today, we're focusing on general partnerships, which serve as a foundational form of business organization. Essentially, a general partnership is a business owned and managed directly by its partners. One of the key advantages of this structure is how easy it is to set up. There are fewer formalities compared to other business models. Additionally, general partnerships offer a great deal of flexibility in how the business is run, allowing partners to tailor operations to their specific needs. However, it's important to understand that while setting one up is straightforward, the legal consequences can be significant. Each partner is personally responsible for the business obligations, which means decisions and liabilities directly affect all partners involved. This structure blends simplicity with important considerations that every business owner should keep in mind. Now, let's dive into the concept of a general partnership. Essentially, a general partnership is a business structure that involves two or more owners. These owners jointly own the business assets, meaning they share in both the investments and the resources of the business. Furthermore, they hold shared management authority, so each partner typically has a say in how the business is run. One critical aspect to understand is that in a general partnership, the owners have unlimited personal liability. This means that each partner is personally responsible for the debts and obligations of the business, which is an important consideration when deciding on this business structure. This summary highlights the core elements that define a general partnership under partnership law. When it comes to forming a general partnership, what's important to understand is that no formal paperwork is strictly necessary. A general partnership can actually be established simply through the actions and interactions of the parties involved, as long as three key elements come together. First, there must be an agreement between the parties, and this agreement doesn't have to be in writing, it can be verbal. Second, the parties must have the intent to create a partnership, meaning they recognize and accept their status as partners. Finally, the business activity itself must be aimed at making a profit. When these three elements, agreement, intent, and profit-driven business activity, are all present, a general partnership legally comes into existence. Now let's delve into the core elements of a partnership agreement, which serves as the blueprint for how the business operates. First, capital contributions are crucial. They determine who puts in what resources, whether that's money, property, or other assets. This sets a clear foundation for each partner's stake in the business. Next, we have profit and loss distribution. It's essential to outline exactly how the financial outcomes are shared among partners, ensuring fairness and avoiding misunderstandings. Finally, management roles define who takes charge of decision-making, who acts on behalf of the partnership, and who has the authority to bind the partnership legally. Clarifying these roles helps maintain smooth operations and accountability within the business. Understanding these components is key to a successful general partnership. When we talk about the law of business and business organizations, one critical risk to understand is unlimited personal liability. This means that your personal assets are directly at risk if your business faces debts or legal claims. Specifically, in a general partnership, the financial responsibility extends beyond the business itself and touches each partner's personal property. So, if the business cannot cover its debts, creditors can go after your own assets, like your home or savings. This liability exposure is a key factor to consider when choosing the type of business structure, as it significantly impacts your personal financial security. Keeping this in mind helps you make informed decisions and manage your risk effectively. Now, let's talk about joint and several liability, which is a fundamental concept in business law and organizations. When partners are jointly liable, creditors have the right to pursue the partnership as a whole to satisfy any debts or obligations. This means the partnership collectively is at risk. On the other hand, individual exposure or several liability means that a creditor can go after just one partner for the entire amount owed. This is a crucial point because it means that even if you are one partner among many, you could be held responsible for the full debt. The critical rule here is that either partner can be held fully responsible. So, whether it's joint or several liability, the financial exposure can be significant for each partner. Understanding this helps in managing risks within a partnership and emphasizes the importance of clear agreements and trust among partners. Now let's talk about the different types of authority in a partnership and who can actually bind the partnership to agreements or actions. First, we have express authority. This is when authority is explicitly granted in the partnership agreement itself, so it's clearly laid out what a partner is allowed to do. Next is implied authority. This isn't written down, but arises from the day-to-day acts that are ordinary and necessary for running the business. Essentially, if something is a normal part of the business, partners have the implied authority to do it. Then there's apparent authority. This happens when third parties reasonably believe, based on the partner's actions or representations, that the partner has the authority to act on behalf of the partnership, even if they don't have actual authority. Finally, we have ratified authority. This occurs when the partnership later accepts or approves an act that was initially unauthorized, effectively binding the partnership to that action. Understanding these distinctions is crucial because they determine when a partner's actions legally commit the partnership. When it comes to partnership governance, there are a few key management rights and duties that every partner should be aware of. First, all partners generally have equal management rights, unless the partnership agreement specifies otherwise. This means that each partner typically has an equal say in how the business is run. Next, partners have a fiduciary duty, which means they must act in the best interest of the partnership as a whole. This responsibility is central to maintaining trust and cooperation among partners. Alongside this, there's a duty of loyalty. Partners need to avoid any self-dealing or conflicts of interest that could harm the partnership. Additionally, partners must exercise a duty of care, which involves acting with reasonable prudence and diligence when making decisions. It's important to note that these default rules aren't set in stone. They can be modified by the partnership agreement if all partners agree to different terms. This flexibility allows partners to tailor governance to best fit their unique business needs. Now let's talk about how profits and losses are distributed in a general partnership. The default rule is that everything is shared equally among partners unless they agree otherwise. So, typically, if there are two partners, they'd split profits and losses 50-50. However, there are other ways to handle this. One option is to distribute according to capital contributions, which means each partner's share is proportional to how much money they put into the business. Finally, partners can also create a custom arrangement, essentially any system they agree upon that suits their specific situation. The key takeaway is that while equal sharing is the starting point, flexibility exists to tailor the distribution as needed. When we talk about partners in a business, it's important to understand that they owe one another certain trust-based duties. These fiduciary duties form the foundation of how partners should conduct themselves. The first one is the duty of care. This means each partner must use reasonable care and apply informed judgment when making decisions that affect the partnership. It ensures decisions are thoughtful and responsible. Next is the duty of loyalty. Partners are expected to avoid any competing interests that could harm the partnership. If conflicts arise, full disclosure is required so that everyone is aware and can address the issue transparently. The third core duty is the duty of obedience. This means partners need to follow the partnership agreement and abide by all applicable laws. It's about staying aligned with the agreed rules and legal requirements. Together, these three fiduciary duties, care, loyalty, and obedience, shape how partners interact and maintain trust within the business. They are not just ethical guidelines, but legal obligations that help protect both the partnership and each individual partner. When a partner decides to leave a business partnership, it sets off a series of important steps that need careful handling. First, the partner must give a formal notice of their intent to withdraw. This raises immediate questions about timing and authority, as everyone needs to understand the next legal actions for the partnership. Next comes the critical stage of dissolution or buyout negotiation. The remaining partners must decide whether to dissolve the firm entirely or continue it by buying out the departing partner's share according to the partnership agreement. Finally, the settlement and exit stage involves adjusting accounts, paying the leaving partner, and formally separating their responsibilities for any future obligations. It's important to remember that departure is not just a single event, but a process that unfolds through these stages, ensuring clarity and fairness for all parties involved. Now, let's talk about the transferability of partnership interests, which is a crucial aspect in business law concerning partnerships. First, we need to distinguish between economic interest and managerial interest. Economic interest refers to the right to receive profits and share in losses. These rights are generally easily transferable, meaning a partner can assign their profit and loss rights to someone else without much restriction. However, this doesn't mean they automatically gain any control over the business. On the other hand, managerial interest, which includes voting and management rights, is quite different. These rights are not automatically transferable. To transfer managerial interest, the consent of the other partners in the partnership is typically required. This restriction exists to maintain control within the existing partnership and ensure that new parties cannot unilaterally gain decision-making power. So, while economic interests can move more freely, managerial interests are closely guarded, requiring agreement among partners before any transfer can take place. This balance helps protect both the financial and operational integrity of the partnership. When it comes to admitting new partners into a business partnership, there are a few key points to keep in mind. First, unanimous consent is crucial. This means that all existing partners must agree before anyone new can join. It ensures that everyone is on the same page and comfortable with the addition. Second, the incoming partner usually makes a capital contribution. This can be in the form of money, property, or even services, which helps support and grow the business. Finally, the partnership agreement needs to be updated. This amendment outlines the new partner's rights, responsibilities, and their share of the business, keeping everything clear and official. These steps help maintain a strong, well-organized partnership as it evolves. Now, let's dive into some important concepts in partnership law, specifically dissolution and winding up. Dissolution refers to the legal event that ends the partnership relationship. This can happen for several reasons, such as mutual agreement between partners, the death of a partner, bankruptcy, illegality, or even a court order. Essentially, it marks the official termination of the partnership. After dissolution, the process of winding up begins. Winding up involves wrapping up the business affairs by collecting any remaining assets, paying off debts, and then distributing whatever is left to the partners according to their rights. It's important to understand that winding up is distinct from dissolution, not just ending the partnership, but settling everything properly afterward. This ensures that all obligations are met and partners receive their fair shares. Now let's talk about dissolution and transition in business partnerships. Dissolution refers to the legal termination of a partnership, and it's important to understand the causes that can lead to this outcome. One common cause is the mutual agreement of all partners to end the partnership. Another is the death of a partner, which can automatically dissolve the partnership unless otherwise agreed. Bankruptcy, either of a partner or the firm itself, also leads to dissolution. If the business becomes illegal for any reason, that too forces an end to the partnership. Additionally, a court decree can legally dissolve a partnership if certain conditions are met. Lastly, a breach of the partnership agreement, where one partner fails to fulfill their obligations, can cause dissolution. These are critical legal events that bring an end to the partnership relationship, and it's essential to be aware of them to manage business transitions smoothly. Here we're comparing general partnerships and limited partnerships to understand their key differences. First, liability is a big distinction. In a general partnership, all partners have unlimited personal liability, meaning they can be held personally responsible for business debts. In contrast, limited partners have liability only up to the amount they invest, but there must be at least one general partner who retains unlimited liability. When it comes to management rights, general partners all have the authority to manage the business unless they decide otherwise among themselves. Limited partners, however, usually do not participate in management, focusing mainly on their investment. Forming a general partnership is straightforward, often requiring no formal filing. but limited partnerships generally need to be formally created through state filings, which adds a layer of legal structure. Finally, in terms of capital contribution, general partners can contribute money, property, or even services to the partnership. Limited partners mostly contribute capital, meaning money or assets, but typically don't provide services or take on management roles. Understanding these distinctions is crucial when deciding which structure best fits your business needs. Here we have a real-world example involving a medical practice run by 3 physicians in a general partnership. One partner signs an equipment lease, while another mishandles patient billing. Because it's a general partnership, liability can extend to each partner's personal assets, so everyone is potentially on the hook for any missteps. Profits and losses get shared according to their partnership agreement, or, if there isn't one, by default rules that apply to partnerships. When a partner leaves, it can create complex issues around how the partnership is valued, how the buyout happens, and whether the business can continue smoothly. Additionally, if a partner breaches their fiduciary duty, the whole firm could face internal disputes or even external lawsuits, showing just how important trust and clear agreements are in partnerships. When we look at partnerships under business law, there are some key points to keep in mind. First, forming a partnership is relatively easy since no formal filing is required. However, this simplicity comes with a significant risk. Each partner is personally liable for the business's obligations without limit. This means creditors can come after personal assets if the business can't meet its debts. Next, fiduciary duties play a crucial role. Partners must act with loyalty, care, and good faith toward each other and the partnership. This legal duty ensures trust and fairness are maintained in the relationship, which is essential for smooth operation. Management in a partnership is typically shared equally among partners. Unless otherwise agreed, all partners have equal rights in managing the business and making decisions. This shared control can be an advantage, but also requires cooperation and clear communication. Finally, having a detailed, written partnership agreement is vital. This document outlines each partner's roles, how profits will be divided, how disputes will be handled, and the terms for exiting the partnership. A well-crafted agreement provides structure and helps prevent conflicts down the line. Overall, understanding these fundamental principles is essential for anyone involved in or considering a partnership. As we wrap up, let's reflect on some key questions that help tie everything together about general partnerships. First, when should you actually choose a partnership structure? It's important to consider the nature of the business and the level of involvement and shared responsibility you expect among partners. Next, what risks need your immediate attention? Identifying and mitigating these early on can save a lot of trouble. Then, how do you protect your personal assets? That's crucial, since partners often face personal liability for business debts. Finally, which terms should you definitely include in your partnership agreement? This document is your roadmap for how the partnership operates, handling everything from authority and fiduciary duties to how the partnership might be dissolved. By considering these questions, you're effectively connecting the dots between formation, liability, authority, duties, and dissolution, creating a solid, practical legal framework to guide your partnership.